Right now on the Daily Debrief, a new lawsuit in the case of an Arizona teacher who admitted sex crimes with a student. Plus, a bizarre request about a soundproof room from the defendant accused of killing a college student. Also, relatives speak of a victim murdered in Florida.
I'm right here, baby. I'm not going anywhere.
Promises unfulfilled, a life cut short.
That is cold, that is calculated, and that is premeditated.
Prosecutors ask for the death penalty against the admitted killer. The defense asks for mercy.
You must know the person that you are called upon to judge.
The Daily Debrief recaps the day in court. It's Monday, July 1st.
Welcome to the Debrief, everybody. Aaron Keller along with Norman Williams and Michael Bryant. A Florida jury must determine whether it's death or life in prison for a man who blamed his probation officer for the murder he admitted committing. Defendant Scott Nelson said he killed Jennifer Fulford because he needed money. Fulford was a personal assistant and nanny to a wealthy man. The defendant said his probation officer interfered with his ability to find a job and housing and believed crime was his only option. Let's begin our look at this phase of the case, the punishment phase, with the prosecution's opening statement.
The first aggravating factor that the state believes applies, that you will find beyond a reasonable doubt, is that Mr. Nelson has previously been convicted of a violent felony. And during Mr. Nelson's testimony, you heard that he was on felony probation. You heard in Mr. Nelson's statement that he killed Jennifer Fulford so she would not testify against him. Those facts establish beyond a reasonable doubt the avoiding arrest aggravating factor. Also, in his statement, we know that Mr. Nelson committed this offense for money. There is no question that Jennifer Lynn Fulford died because Mr. Nelson wanted cash. That is referred to in the Florida statutes, and you will hear it described as the pecuniary gain aggravating factor. That the murder was committed for pecuniary gain. And moving on to the next to last aggravator we're going to talk about. You heard testimony from the medical examiner, and you heard testimony through Mr. Nelson's confession to law enforcement about how Jennifer Lynn Fulford was terrified, was crying, was begging for her life in the 1-hour drive he took her on from Reed Berman's house in Winter Park to the shadow of Epcot Center.
Those are the state's suggested aggravating factors. From there, the state reminded jurors of the facts of the crime.
What we have in this case is a murder that was committed after the planning of it began some 2 weeks before, with the purchase of various items at a Walmart. The duct tape and the zip ties comprise parts of a murder kit, and that's all there is to it. That is cold, that is calculated, and that is premeditated preparation for this murder, even though Jennifer Lynn Fulford may not have been the target of the murder at that time. But that doesn't matter for the aggravating factor.
The defense described a broken home with a transient alcoholic father and a mentally ill mother as the starting point for a lifetime of emotional and physical abuse for the defendant.
The death penalty isn't designed simply for the most shocking of crimes. The system requires that mercy temper justice. Before considering the death penalty, you must know the person that you are called upon to judge. You must consider his individual circumstances. Now, Mr. Nelson's individual circumstances include an abusive and later absent father, a schizophrenic mother, abusive older brothers, decades of alcohol and drug abuse, and as you heard last week, almost 25 years in the Federal Bureau of Prisons, most of which was served in solitary confinement. He has been diagnosed with severe mental illness, has cognitive impairments from brain damage and other medical issues. All of these problems affected his ability to make rational decisions. And in September of 2017, his mental illness combined with his homelessness, his helplessness, and his emptiness put him in the position that we find ourselves today. It is now our hope to show you how Scot Nelson got to this point. Now, Ms. Fulford's death was a tragedy, it's an injustice, and Mr. Nelson is responsible. Nothing that we present to you over the next week or so is intended to reduce either her tragedy or Mr. Nelson's responsibility for it.
Next, the defense pointed to abuse against the defendant while he was in prison. And the case went back to the probation officer after that, who the defendant blamed for his troubles.
He suffered physical abuse and was raped by a cellmate. He suffered PTSD from the abuse that he suffered as a child and in prison. But at the same time, solitary confinement was taking its toll on Scot's fragile mental health. He became institutionalized, by which I mean his time of incarceration created deficits in social and life skills. Clinical psychology recognizes that people who have been incarcerated for long periods of time, who haven't had responsibilities or independence, haven't had to make decisions of their own, often become unable to manage the regular demands of everyday life upon their release. But upon his last release in May of 2017, he was pushed out the front door and told to check in to probation in downtown Orlando. During the next few months, Scot tried to get his life back in order. He had no ID, he had trouble finding a job and a place to live. He spent some time living at the Orlando Rescue Mission, and he eventually found a job as a painter. He was able to stay in the office when the owner took him in. But as you heard, his federal probation officer scared his employer, got him kicked out and on the streets again. And during that month of September, Scot was living on the streets, trying to manage his colostomy while homeless, turning back to his addictions. His PTSD, his depression, his institutionalization, his lack of coping skills, and stress of everything culminated into a storm that led to this tragedy.
The first witnesses for the state were employees of a bank that the defendant, Nelson, robbed. That's why he was on parole when he killed the victim at the center of the current case.
My assistant manager came and introduced me to a customer that said he wanted to open up a new account. And when I accepted him in my office, and when he came in my office, he had a letter, and he asked me to read that letter. It was a 3-page letter, and to read it carefully. I was to get somebody in charge, and that he had a bomb, and that he would detonate it, and I had to wait 30 minutes till after he left, or he would detonate that bomb, and he wanted cash from our vault.
Did he show you what he told you was a bomb?
He had a black briefcase that he sat next to him on the chair next. There was 2 chairs in front of my desk. I was in the office. I was not a teller. I was a banker. And he reached into his briefcase and he pulled out, it looked like a little remote. When I read the first line, I looked up at him and he kind of like shook his head yes. And he pulled that out, and I got nervous and I stood up in front of my desk and I told him to put that away, that it wasn't necessary, that if he let me read the letter, I will follow his instructions, and that I didn't want anybody to get hurt.
Another bank employee who was present for the attempted heist continued the story.
I told him that if he went beyond this point into this room, into the teller line, that everybody would know that we were being robbed, because only bank personnel could come back there. He said, okay, don't try anything funny, I'll be watching. Don't remember I have a bomb. So Carol and I went to the break room. Once we were in the break room, there was 2 tellers that were in the break room. I informed them that we were being robbed. They asked if we called the police. I told them no. One of them proceeded to call the police.
Did you gather up money from inside the vault?
Yes.
Did you put the money in a bag?
Yes.
About how much money did you gather up?
Oh, that I do not recall. I couldn't tell you. It was a decent sized bag. He told us to make sure it was full and to have larger bills. We tried to layer it so it appeared that he got all the large bills, so we put small, like 1s and 5s on the bottom and put like 50s and 100s on top. But the exact amount we weren't really keeping track of. We were just trying to give the appearance that there was maybe a little bit more money than there was.
Okay.
Once the bag was full, Stephanie and I walked out of the vault. We handed him the bag. And he said, remember, I believe 30 minutes, because in the note it said that after he left, that we were not to hit any alarms to call the police for a set amount of time. And then he left. As soon as he walked out the door, we locked the door behind him.
Well, police caught up with him. Next, a police officer described exactly what happened when officers approached Nelson not far from the bank.
He told you that it was not a real bomb.
He did.
He had made this fake device out of garbage he found in the woods.
That's correct.
He had been living in the woods nearby the bank.
Yes, ma'am.
And he agreed to tell you everything in exchange for cigarettes.
That's correct.
And so you had a recorded interview with him
Yes, ma'am.
where he was very open and told you everything about the case.
Yes, ma'am.
And he told you about his prior history.
He did.
And he showed you the campsite where he had been living and where he found the items to make this fake bomb.
That is correct.
Okay. And it was your impression that Mr. Nelson was attempting to just go back to jail?
It seemed to me that he was more cooperative than normal, than I usually experience.
Well, we learned in this case that this defendant is indeed talkative. So with us tonight are attorneys Michael Bryant, Norman Williams. Norman, this is the stage when the state presents the aggravators, and they have several, one of which is this bank robbery, and then the defense puts the mitigators, also known as the sob story, of everything that ever happened that was wrong with this defendant. So the jury has to weigh them here, but I'm wondering if both of these kind of fit together, where the mitigators are sort of the same thing the defense is saying are the aggravator. You know, it's like, is the jury just put this together and say this guy is irredeemable at this point?
No, I think what you're realizing is that the two sets of information are kind of canceling each other out in a way, and for him to put forward that the state is who's responsible for his aggravating factors, it also makes mitigating them kind of difficult.
Yeah, Michael, my point here is sort of like this, that the defense is saying it's a mitigator, that he was serving time in prison, and the state's saying, well, that's an aggravator because he was in prison because he did something wrong, right, and he's living a crime spree here.
Yeah, I don't like blaming the system that you got into breaking the law. You know, prove to me that you were broken before you got into prison, and that aggravated the situation. I go along with that, but I have to say, a 3-page bank note. Who writes 3 pages to say, I got a bomb, give me all the money? Scott Nelson writes 3 pages.
Yeah, exactly. I mean, we listened to this guy's testimony on the stand last week. We were sitting here, the three of us, with jaws on the table. So, Norman, it doesn't surprise me to hear that back when he did the bank robbery, he wanted to spill his guts to that officer. Did he really say that he told all because he wanted cigarettes?
Yes, he did. Cigarettes, and then in the future, it's all about pizza. I don't get it. I don't get it.
I don't get it either. Michael Bryant, do you understand what's going on here?
No, I mean, the guy wants a forum. He's got it. He's already given us Act 1. That was in the guilt phase. Act 2 is to come in the penalty phase.
Yes, and still ahead tonight here on The Debrief, a new civil suit in the case of an Arizona teacher who admitted to sex crimes with a 13-year-old student. Plus, we're going to take you back inside the courtroom for the trial of Scot Nelson, as relatives describe the victim as a loving, protective mother, and a juror gets thrown off the case. That's when we return. Welcome back to The Debrief, ladies and gentlemen. Remember the case of the Arizona teacher who admitted to sex crimes with a 13-year-old student? A new lawsuit suggests school officials knew about it and did nothing. Brittany Zamora will be sentenced just 12 days from today, but the parents of her victim say the school's principal heard rumors about her sexual interests and failed to report them to the authorities. Had he acted in time, the lawsuit says the first actual sexual contact between Zamora and the 13-year-old likely would not have occurred. An update now in the case of Mackenzie Lewick, where defendant Ayula Ajayi has been arrested and charged with murdering the Salt Lake City college student. A contractor is telling a Salt Lake City TV station that the defendant asked for a soundproof room in his home. These are pictures of police raiding it. The details of the request included hooks in concrete walls and a thumb lock. The contractor said his gut feeling was that the room would have been for something bad. The contractor told another area TV station that the defendant wanted to use the room to hide booze from his Mormon girlfriend. Now back to the Florida death penalty trial of Scot Nelson. The victim's daughter testified remotely because she recently broke her ankle, she said, and shared a conversation about the victim where they talked of all things about death and a promise from the victim to always be there. It was a promise unfulfilled.
My mom was my best friend. I mean that in every sense of the phrase. We laughed hard. We talked to each other about everything. We held each other's secrets. We checked in on one another, and everything we did felt like an adventure. We bickered. We cried on each other's shoulder. She taught me how to dance, and we danced all the time. She taught me how to sing, and we sang all the time. We were there for one another. And we loved each other more than we loved ourselves. Because that's who my mom was. She loved in a way that made you feel like you were the only human being on the planet. And that love was truly unconditional. But when I was 12 years old, I got a movie called What Dreams May Come. The movie was about death. She stopped the movie and asked me if I was okay. I told her I just couldn't imagine living in a world that she wasn't in. That I didn't know what to do if I had ever lost her. She told me that she was also scared. The movie was making her think about things that she couldn't handle if they happened in reality. We watched the rest of the movie, and every year from then on, we watched it again. But my mom never got to see me turn 30 years old. She will never dance with me at my wedding. We will never sing another song together. She won't be there for the birth of my children, and they will never know her vast love and the soothing sound of her voice.
Also testifying was a friend who knew the victim was missing, but who found out about her death at work.
Everyone has a different experience about the day we found out about her death. Mine was in the bathroom at work. I got a call from Robert, and I knew something happened when I saw the phone number, which is why I walked into the bathroom. I didn't cry at first. I didn't know what to say. Maybe I knew before I even got the call. I was in denial. I realized now I was in shock. I shortly afterwards started hysterically crying. Unfortunately, there's no bereavement period for best friends. I called her cell phone many times just to hear her voice on her voicemail. I wanted to call her today because as my best friend and confidant, I would have called her to talk about writing this and how heartbreaking it is. Jen's murder robbed the world of a best friend, wife, mother, grandmother, and the best nanny in the world.
The jury in this case reported an issue to the court where one juror jumped into a discussion about about scheduling, I should say, a discussion about court scheduling with an opinion about the case. So here, the judge questions that juror. You can hear the juror's voice, but you won't see his face.
It's alleged that you're in the jury room this morning. You said words to the effect of, you would not vote for the death penalty unless he killed 10 other people. There was no point in discussing further, or words to that effect. Is that correct?
I said it would be very important for me to go after the death penalty after everything. I didn't. I wasn't asking for everybody else's opinion. And what was the last part of that too? Because
why don't you tell me what you said?
I forget why it was brought up, but I basically said, with everything I've heard, I don't know if I can go after the death penalty. If I'm going to have trouble committing somebody to death for what I've been told already. And that it wasn't me trying to persuade anybody else in the room. It was just, I shouldn't have said it, obviously.
Do you recall the court's instruction multiple times to not discuss this case amongst yourselves or with anyone else?
I do.
Why did you then say what you said?
I believe there was a discussion about how long the case would take. I don't recall who was saying that it's going to take a while, and was like, I think that's maybe why I chimed in.
Let's see what the panel thinks about this whole issue here. Michael Bryant, let me try to understand what's going on here. So the bottom line is the juror got kicked off the case, but the juror sort of dancing around what he said, because at this point the juror knows he's in trouble.
This bothers me a lot because it's what we didn't hear that's probably more damaging. Okay, so he says that he offered an opinion against the court's instruction as to his thoughts on putting a man to death who hasn't killed, 10 people. Well, what was going on during the guilt phase with this guy? Who knows what he was saying during that process? I just think it makes the whole thing stink. I just don't think he was honest going into this trial.
Well, it seemed to me like the judge was basically cross-examining him, Norman, to try to get to the bottom of what happened. First the juror's like, well, I don't really remember. And then it comes out, oh, yeah, this is how it came out. Was this something, though, that was a little bit more innocent than perhaps some people might think, where, okay, they're talking randomly about, well, gee, how long is this going to take? And then the juror just sort of blurts out what's on his mind and then reels back and says, oh, wait a minute, I shouldn't have done that. I mean,
I think this juror is lucky. He's lucky that the judge is kind of being soft on him, because he was asked this question, I'm sure, during voir dire. Do you have any feelings against the death penalty? And he should have said, yes, I do.
Well, maybe he didn't have them at the beginning. Maybe he just doesn't feel this case is death warranted. It seems like that's what his opinion is.
And if he felt that way, he would have been disqualified as a juror.
Certainly. So you agree that this is a good move, kick this guy off the case?
I would want him to stay.
Well, as a defense attorney, certainly.
I love this guy, but as far as the prosecution goes, nah, he has to go.
Michael Bryant.
Oh, yeah, he definitely had to go, and I was wondering what the waffling was about. He had to go. They had plenty of alternates. Yeah, he had to go.
What's scary, though, is how many times do we sit here, Michael, and we see judges listen to things like this, and they find some way to say, well, I'll try to keep the juror on the case. Of course, in this instance, the opinion was a little bit more harsh than sometimes we see, but oftentimes they try to admonish the juror, look, you realize you need to set that aside and continue to listen, and then the juror says yes, and then things roll along.
Yeah, the judge has to decide how heavy a problem is this going to be, and in this case he made the right call, but you're right, lesser circumstances, you leave him on.
Gentlemen, great to see you on the debrief. Thanks, we are wrapping up now. We hope you'll join us tomorrow starting at 9 a.m. for more live coverage of trials around the country. The debrief is back at 5. Good night.